I will speak about the same topic, but under German law. The German code does not specifically provide for employer's liability for damages caused by his or her employee in the course of their employment. The German BGB, it means Bürgerliches Gesetzbuch, rather provides a more general rule by stating that a person who appoints another to do any work for him or his is bound to compensate for any damage the other unlawfully caused a third party in the performance of his or her work, unless the master has exercised the necessary care in the selection and supervision of his servant. First, I must emphasize that in the literature I found two terms for the employer, as previously mentioned, the master, and also I found that this article 831 describes an employer as a principal, while the employee is a servant or subordinate who is dependent on the instructions of the master or the principal. Employees also include senior officials and executives, but generally exclude employed commercial representatives because of their autonomy. The employer can even be liable for independent contractors and traders if they are dependent of his instructions. So, contrary to other legal systems, the employer is not strictly liable for injuries caused by his employees. Under German tort law. Liability under this article is based on the employer's own fault with respect to inadequate selection and supervision of his servants. So the employer has two defenses. First, he is not liable if he proves that he has exercised the necessary care in the selection and supervision the employees and in the procurement of tools. And second, he is not liable if the injury would also have been caused if he had taken such reasonable care. But first, the preconditions for the employer's liability. All systems require the causation of damage by a person, so by an employee appointed to do any work for the employer. Also, a relationship by which one person may be held liable for the harmful acts of others. Also, the commission of wrongdoing by the employee or subordinate, and that liability is confined to a specific set of circumstances, but it must be within the course of the employment. So, for the liability of the employer to be triggered, the employee must have committed, in German it is the word Tatbestand, but it is in the sense of next article 823, section 1 and 2. And it means that his conduct was in principle unlawful. So generally, it is sufficient that the employee's conduct can be considered to be a sufficient cause of the damage. But if the employee had acted with due care, the employer is not liable. In such cases, the employer's defenses do not need any further examination or assessment, since previously Article 831 does not require the employer's intention or negligence. His liability is not necessary to establish the employer's liability. But if the employee acted intentionally or negligently, he or she will be jointly and severally liable with the employer. So, as previously mentioned, that the liability is confined to a specific set of circumstances. The employee's conduct has to fall within the scope of his duty, which means that there has to be immediate relationship between the activity he has been instructed to perform and the act causing the damage. If the employer is liable and he has paid the damage to the victim, he only has a right of recourse against the employee if the latter acted intentionally or with gross negligence. Also, the employee has a right of recourse against the employer if he himself paid the damage to the victim and did not act intentionally. And regarding the relationship between the employer and the employee, there is the control test, and it is most commonly applied to determine that relationship between the employee and the employer, and it refers to the degree of direction and supervision of exercised by the employer. And the focus of this test is no longer of the fact of instructing the employee how to do his job, but on the possibility of being able to control the act of the employee's actions. On this basis, the liability may be extended to the independent contractors and traders, but depending on the circumstances under which they work and whether a general right to give instructions have been retained. So, according to the Federal Supreme Court, a person is a servant under this Article 831 if he or she is generally or for specific occasion entrusted with the performance of the function in the employer's sphere of influence, provided the relationship between the employer and the employee is determined by social and economic dependency. In principle, liability according this Article 831 only refers to the employment of person who acts in the employer's interest and they are bound by the employer's instructions or directives. Without this prerequisite, the employer's liability for incidents occurring in his organizational sphere could not be justified. And regarding this fault-based liability, in doctrine, legal authors are not satisfied with this provision because they are arguing that it is not necessary and it is not relevant whether an employer has acted with due care in relation to choice, directions and supervision of an employee, but in the meantime the courts have looked for other ways to achieve satisfactory result. It is in the Article 31, and it is the liability for legal person for their organs. So in the word of the statute, the association is liable for the damage to a third party that the board, a member of the board, or another constitutionally appointed representative causes through an act committed by them in carrying out the business with which they have been entrusted, where the act gives rise to a liability in damages. So formally, these rules establishes liability for the organ's own conduct rather than liability for others, because the liability of the employer is a vicarious liability. But the result is the same. The case law has extended the provision by also applying it to person exercising management functions within large organizations, such as branch directors or head of departments. So also there is a second explanation that the employer's liability regarding this article can be based on Article 823 in the previous slide, and it is the case if an employer has negligently failed to organize his business in a proper manner. So this is known as organizational negligence, and it is the employer's duty to organize his business properly, and he cannot leave the organization in the hands of managers and other people who is in the scope of that management organization. And if he does so and the damage was caused, he is liable for the damage. And generally the duty obliges the employer to organize and supervise the management and the activities of his employees in such a way, and it depends on the circumstances of the case. And I can give one example for that. It was in Gran Canaria when the tour operator failed to ensure the safety of the hotel, and the guest who was injured when he fell from the balcony. So that was the fail to ensure that safety. And third, even the employer can exonerate himself from liability under Article 831. He has to indemnify the employee if the latter is personally or with gross negligent liable. So the rule is intended to protect the employee, but its consequence is that in the end the employer has to pay for the damage wrongfully and negligently caused by his employee. And moreover, the company's liability insurance generally covers the employer's liability. So this means that if the employee is liable, the claimant in most cases will find a solvent debtor. When it comes to strict liability, I found more than 20 statutes in German law. It's separate statutes regarding to hazardous things and activities. So as in Serbian law, in the German is the same. On the court is to decide is one thing is hazardous or not. And when it comes to the state's liability, in doctrine the state is strict liable for its servants, and the servants if are liable for the damage they cause by intentionally or negligently when they breach their official duty. And this includes all activities involving the public interest. So the legal position of the person working for the public service is not relevant, and someone working on the basis of a private law contract can be considered an official in the sense of that article, which prescribes who is a public servant. They can be, for example, soldiers, majors, and parliamentarians. And to conclude, as I mentioned, although Article 381 of BGB stipulates the employer's fault-based liability, case law and doctrine look for other ways to determine strict liability as the primary, because in the end the employer has to pay for the damage wrongfully and negligently caused by his employee. So, like in other European countries, strict liability is dominant liability in Central and Eastern European countries.
Thank you, Milica.